Hello viewers and students. This is Dr. Kashinath Neharkar. I welcome you in my YouTube channel at lecture series on labor laws first. Friends, I welcome you in second part of the topic when strike and lockout becomes illegal under section 24 of Industrial Dispute Act. Friends, in earlier lecture we have discussed those circumstances which works as a prohibition of strike and lockout as in public utilities services as as provided under section 22, or the general prohibition of strike and lockout as it is provided under section 23. And now we are continuing the next part where section 24 of the act deals with the conditions and circumstances where the strike or lockout becomes illegal. Actually, the title of section 22 and 23 is a prohibition of strike and lockout in public utility services, or the general prohibition of strike and lockout. And here section 24 of the act works as when strike or lockout becomes illegal. We are going to discuss these circumstances. Friends, as we know, the section 22, section 23 plays very important role in deciding when a strike is called as a legal or illegal. So now, before going to discuss section 24, you must know what are the important aspects of section 22 and 23. So by assuming that you know what is section 22 and 23, we are going to discuss what is 24. So when strike and lockout becomes illegal, this is specifically dealt by section 24. So that provides following circumstances. Section 24 deals with the circumstances when strike or lockout becomes illegal. So these circumstances or these conditions are as under when, so it means when a strike or lockout is commenced in following circumstances, that lockout or strike will be called as illegal. So we must know what are those circumstances that are specifically provided by section 24. So the first circumstance is if a lockout or the strike is commenced in contravention of section 24. You know what is section 24. Section 24 is the prohibition of strike and lockout in public utility services. So the workers or the employer of public utility services, they cannot commence the strike in circumstances that are provided by section 22 clause 1. So then second condition is if the strike and lockout is commenced in contravention of section 23. See, we know section 23 is nothing but the general prohibition of strike and lockout in all kind of industries. It provides the conditions and circumstances where the workers cannot go on a strike or the employees can commence the lockout. So, and if such strike is commenced or lockout is commenced in contravention of those conditions, that strike or lockout becomes illegal. This is the second condition. Then third condition is that if it is continued in contravention of section 3 of section 10A of Industrial Dispute Act. So that is when any arbitration award is in operation, during that period also strike shall not be commenced. And lastly, as you know, though this is not the important essential of section 24, but the strike which is declared as a in consequence of illegal lockout is not considered as an illegal strike, or the lockout which is commenced in consequence of illegal strike, that is also not called as a illegal strike. Friends, now we know the circumstances where the commencement of lockout or the commencement of strike is called as illegal. Now we must see What are the consequences of illegal strike and lockout? Section 24 specifically again provides the consequences for illegal strike and lockout. Therefore, it provides certain penalties because section 22, section 23 both are the prohibitions. It imposes an obligation upon workers as well as employer not to breach such prohibitions. But even the prohibitions are there, this if the strike and lockout is commenced in violation of such section, what shall be the penalty? Penalty is provided by section 26 of that act. So first penalty is penalty for illegal strike. Section 21 clause 1 of the act deals with penalty for illegal strike, and that penalty or the punishment is that the workman who commences, who continues, or who participates in a strike which is illegal shall be punishable with following punishments. So three acts are there mentioned which are called as misconduct, we can say here. That also can be the offensive act. So that is the person who commences, workman who commences the illegal strike, the person continues the illegal strike, and the person who participates in a strike. Such workmen can be punished with following punishments, that is the punishment with imprisonment up to 1 month, or fine up to rupees 50, or with both. So this is the first penalty for illegal strike. Second penalty is for illegal lockout, that is specifically provided by section 26 clause 2, and according to that definition, employer is punishable if any employer commences the lockout in violation of section 22 or 23. In such circumstances, he will be punished with imprisonment up to 6 months, or the fine up to rupees 1000, or with both. This is the second penalty. Now we have to see the next penalty, and that penalty is provided by section 27 of the act. That penalty is penalty for instigation for illegal strike and lockout. See, the instigation is nothing but one kind of inciteness, so one kind of provocation to other persons to declare illegal strike or lockout. In such circumstances, the person who is responsible for instigation is also punished. So the person who instigates or who incite other persons to take part in a strike or lockout, such person shall be punished with imprisonment up to 6 months, or the fine up to rupees 1000, or with both. The next penalty is penalty for financial aid for illegal strike or lockout. So this is also one kind of instigation, and this is also the punishable act. Here the person who knowingly expends or who knowingly apply any money to support illegal strike or lockout, it is also the punishable act under the Industrial Dispute Act. So providing financial support to illegal strike or lockout itself is offense under the Industrial Dispute Act. So the person who is guilty of such offense shall be punishable with imprisonment up to 6 months, or the fine up to rupees 1000, or with both. Now we are going to discuss another important question relating to wages for the period of strike. The Industrial Dispute Act provides, though there is no specific provision regarding whether the workers are entitled to wages for the period of strike, the general rule is that workers are not entitled to wages for the period of illegal strike. When they commenced illegal strike, they participated or they continued the illegal strike, for that period they are not entitled to get the strike, but they are entitled to get the wages for the period of illegal lockout. So regarding that, there is a case law that is Crompton Greaves versus its workman. The Supreme Court explained the question of whether the workers are entitled to get the wages during the period of strike and lockout, and the Supreme Court held that the workers are entitled to get the wages if the strike is legal and justified. It means for illegal strike or the strike which is not justified, the workers cannot go on a strike. So friends, these are the two lectures that deals with the circumstances and conditions or the provisions relating to when strike or lockout is legal and when strike and lockout is illegal. When any strike or lockout is declared without violating, without breaching any terms and conditions which are provided by section 22 or 23, then such a strike or lockout will be called as legal. But where any strike or lockout is commenced by breaching the terms and conditions of section 22 and 23, such strike or lockout becomes illegal. So friends, if you like my video, please like it, please share it with your students, and do not forget to subscribe my YouTube channel. So friends, thank you.